I'm Elizabeth Talbot, and I'm here with attorney Matthew Talbot, trust, probate, and elder law attorney in Walnut Creek, California. And we are talking about today contracts to make a will, which are an interesting part of probate law that not a lot of people know about. So first we're going to talk about the case of Sam Simon, who is a Simpsons co-creator, and a lawsuit that his girlfriend brought after he died last year for $5 million, saying that he broke a contract to make a will. So Matt, can you tell us what a contract to make a will is?
Of course, I'd be happy to. So in these types of situations, the contract to make a will is where somebody says, and this was an oral contract to make a will, which is even more complicated, but essentially I will make a will and I will include certain distributions in that will. So I think in this instance, he said to his girlfriend something along the lines of, if you move in and take care of me, I will make a will and I will give you $5 million in that will. Is that correct?
Something along that line. He repeatedly promised his girlfriend that he would financially take care of her. Again, Sam Simon, very rich, being a Simpsons co-creator. I don't know if there were money specifics promised to her.
And so then he passed, and it was a situation where he had never done that. So she's in this case suing because of the breach of this contract. And she's trying to get what's called specific performance of the contract, which is to say the court would enforce the contract to make a will and give her the sum of money that she is requesting. And I actually have several of these matters ongoing right now in my own practice. They're not particularly common, but I have handled some of them, and I have some of them right now. So the issue that you really have to look at is whether or not you have clear and convincing evidence of the contract. And what's helpful for the girlfriend here, and this is at least what she states, I'm not certain the truth of the matter, is that she states that she relied on his representations and took an action based off that. So it wasn't that he said, I'm going to make a will and I'm going to give you $1 million, and she said, great, I appreciate that. She said, I will change my lifestyle and take care of you in exchange for these distributions. So,
yeah, I believe she quit her job.
So what that means is it's called equitable estoppel. That benefits her in proving or trying to be successful, because she can argue that he made this argument and he made this agreement, and the proof partially is the fact that I made these changes in my life, and it would be to my detriment for it not to be enforced.
So I think the bottom line for me as someone who's not an attorney is that there actually is quite a lot of a power in an oral contract or just a promise to someone. And if that promise can be proven, either by hearsay or another way, the court system will honor that.
Yes, and one of the exceptions to hearsay relates to wills. So it may not be the situation that the spoken evidence that Elizabeth is talking about would be precluded from the court due to hearsay. There may be an exception for it. So it ultimately depends on what evidence you have. I'll note that they actually changed the law in 2001 to, in my view, expand the exception for oral contracts to make will, making it easier, in my view, if you look at the change from the earlier law to the law that was enacted at that time, to make it easier to enforce oral contracts to make a will. So I think this is something that the legislature looked at and saw that there were these types of cases coming up. They were complicated, and that they wanted to make it easier for the person claiming that this oral contract was entered into to enforce it if they had that clear and convincing evidence.
Okay, thank you very much for joining us today. Thank you, Matthew.
Thank you.